Welcome, everybody. We'll get started here for today's webinar. Just a couple quick admin items. So you should be able to chat in the chat box, and I'll be monitoring that as we go as Chris and Phil and myself present. So if you have questions, it'd be very helpful if you add them there, and we'll have a Q&A at the end. So we'll make sure we address some of those questions. Also, after this webinar, if you know anyone who would like to see it and wasn't able to join, or you just want a copy of it to share with your team, we will distribute the video recording of this webinar hereafter. So questions, please log them in the comments, raise your hand, we'll address them at the end, and recording after the webinar today. So thanks everybody for joining. I see a lot of Risk 360 clients in here, so you guys probably know who we are. Thanks for joining. Welcome here. But if you're not familiar with Risk 360, what we do is we really help organizations build out security, privacy, and compliance programs. So if you want to build a program, if you're looking to assess your program, or if you want to get certified, that's really our bread and butter. We help a lot of organizations in the privacy space. So if you're dealing with HIPAA, GDPR, CCPA, or other privacy and compliance regulations, that's right up our alley. We also serve as the data protection officer for a lot of our clients. And then on the security side, if you're hearing things like SOC 2, high trust, ISO 27001, we also have a really good practice that works in those areas. So let me introduce myself and the presenters today. So myself, I'm the co-founder of Risk 360. I help lead our security and our privacy practice. I'm a certified privacy manager, and I'll be y'all's guide a little bit here today and MC and answer questions as we go. The two presenters that I'd like to introduce are Philip Brudney and Christopher Ventura. Phil is a fellow in privacy with the IAPP. He also has a ton of experience as a virtual DPO for clients. He helps lead privacy research here at Risk 360. So if you've read any of our white papers or some of our thought leadership, a lot of that came through Phil, and he helps a lot of our clients build out privacy programs. So has a lot of experience, especially with high growth tech clients. Chris Ventura is our second speaker. He's an attorney with the John Marshall Law School and Georgetown University Law Center. Very interesting background. He served as a law clerk for the chairman of the U.S. House of Representatives Judiciary Committee. So he was on an oversight committee that helped oversee things like Google, Facebook, some of the tech giants, and some of the things they're doing around the security and tech space. So he'll be able to share some of those stories with us today and some of that expertise. As you're getting ready today, there's a few things that we're trying to accomplish. So if you're thinking about privacy and you have clients asking about security and privacy, we want to give you some of the playbook. How do you think about those questions that prospective clients and your partners and customers are asking about? If you're seeing privacy land in contracts and you're wondering what is your risk profile based on those contractual requirements, we're going to talk through some of those examples. So we want to make sure that you guys can answer some of that and have some tools in your tool bag to think about that. We'll talk about some of the regulations we're seeing out there. So HIPAA, GDPR, CCPA, CPR are some of the common ones. We'll talk about some of the privacy principles along with those and how you can potentially meet those regulatory requirements. And then a lot of executives, and you may be asking this, answering these types of questions with your executives, is this here to stay? Is privacy a big enough risk where you really need to take action and build out a program, or do you just need to navigate this storm in the meantime and see if it settles down? So we'll talk about some trends. And then we'll close out with a playbook. So what do you do? What are the actions that your organization can take when you're starting to build out a privacy program that's the right size to fit? So what to expect today? So I'm going to hand it off to Chris here in just a second. He's going to provide some really important historical context in terms of privacy and why it's important. He'll talk about privacy principles, which is a theme that you'll see throughout this webinar today. We take a principles-based approach rather than focusing on any particular regulation. He'll talk a little bit about that. Then we'll pass it off to Phil, and he'll talk about common challenges when you're building out a privacy program. And based on us doing this for dozens of clients, hundreds of clients, we'll talk about the solutions that we see fit for different organizations in their industries. And then when it comes to contracts, we see a lot of different clauses in contracts that trip companies up and present different types of risk. So we pulled out 3 specific examples, and we want to show how a contractual commitment might result in different types of actions and how to interpret those. And then at the end, we'll hand it back off to me, and I'll talk a little bit about our privacy playbook. I'll give you a cheat sheet on some things that you can do today to start building out a privacy playbook, and then we'll open it up to QA. So without further ado, want to hand it off to our privacy expert, Christopher Ventura.
All right, thank you for that introduction, Christian. So I guess where we'll start is, why does privacy matter to people exactly? Personally, I believe there's something primal about privacy, and as humans, we have this sort of natural inclination to feel safe in secrecy. And data, especially sensitive data, like personally identifiable information, is powerful because it can be leveraged to influence or control a data subject. So for our safety, we tend to keep things secret. We keep things secret from other people, from businesses, and from the government. But what happens when the right to keep information secret is violated? So we'll be looking at a case study here to examine that issue a little further. Now, like any tool, data collection devices and processing capabilities can be misused to violate the privacy rights of people, which historically has resulted in the jeopardization of data subject security. Now, for historical context, let's sort of wind back the clock to when data processing industry was still in its infancy. So like the early 1900s, back then, early computers were basically these massive tabulation machines that relied on punch cards to read and write and compute sets of data. Now, these punch cards were essentially the first iteration of memory cards. They were stiff pieces of paper with hundreds of perforated circles organized into neat rows. Tabs could then be punched out so that the presence of one of those perforated circles would represent a unit of binary code, like a 1 or a 0. Now, at the time, this technology was revolutionary because it automated computation. So you might be asking yourself, well, what was it used for? Well, the history is a little bit dark, but nonetheless, this case study is important because it frames the potential risks that could arise with enhanced data processing capability that's made possible by technological advancements. Now, in 2001, investigative author Edwin Black published a renowned book, IBM and the Holocaust. And this revealed the shocking business relationship between American computer manufacturer IBM and the Nazi Party during World War II. Well, what did his research uncover? Well, Black found that in 1939, the Nazis extracted Germans' biometric data relating to gender, age, religious affiliation from census reports and translated that information onto these punch cards so that the data could then be processed. Racial characteristics were recorded and fed into the Deutsch-Hollerith Maschinen Hesselschlaf tabulation machines for processing. And we call it DHOMAG for short. Originally, the DHOMAG machines and the entity itself, they were a vendor of IBM up until IBM acquired a 90% stake. And in his book, Black evidenced that the punch cards, the machinery, training, servicing, and special project work, such as the population census data and identification, were managed directly by IBM headquarters in New York, which facilitated the systematic elimination of certain Europeans by the Nazi Party. And these findings in his book created quite the scandal when it was published. Now, the takeaway here isn't whether IBM knew or should have known that the DHOMAG machines were going to be used for the Nazis' final solution, for example, but instead, let's ask ourselves, as data collection and processing capabilities continue to advance, what assurances do we have that private companies aren't going to use these powers to violate the rights of data subjects? Well, the answer here is pretty simple: compliance. And before we get to compliance, let's first discuss privacy rights more generally. And as a preface to what Phil's going to be talking about later on in this webinar, keep in mind that one of the central goals of the EU's General Data Protection Regulation, GDPR, is to provide and ensure that there are adequate data protections for EU subjects when information is transferred to third-party nations. So that's a pretty important piece that frames exactly why we're going to be analyzing the sources of privacy rights in general. And so let's ask, where do these privacy rights come from? We've identified 4 key sources. It comes from the Constitution, common law, by statute, or rights conferred by others, by people, businesses, organizations, through private agreement. Now let's examine these rights a little more closely. So the U.S. Constitution originally contained no express right to privacy. The Bill of Rights, however, which is comprised of the first 10 amendments to the U.S. Constitution, does reflect the desire of the framers to provide protections against violations of privacy rights. For example, the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, it addresses the right to privacy with respect to one's body, their domicile, and their possessions. Additionally, certain states have incorporated the right to privacy into their state constitutions. For example, Article 1, Section 1 of the California Constitution reads that all people, by nature, are free and independent and have inalienable rights. And among these rights include enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. That's a pretty big deal that the California Constitution specifically incorporates privacy into their document. This signals that privacy is essential to liberty and to freedom. But if privacy is so important, why can't Congress just pass a law that prohibits the collection of certain sensitive information? Well, the central issue with that stems from the balancing of constitutional rights. In a 1905 constitutional law case, Lochner v. New York, the Supreme Court invalidated a law passed by a state legislature that attempted to restrict people's right to contract. The court held that such restrictions would violate the Due Process Clause, which prohibits unreasonable, unnecessary, and arbitrary interference with one's right and liberty to contract. So there's essentially a constitutional basis for both protecting citizens' privacy from invasive government intrusion under the Fourth Amendment, as well as also protecting citizens' right to private contract under Lochner. So this affirms that people have the right to consent to the invasion of their privacy when they're contracting for goods and services. A solid example would be consenting to the invasion of privacy by engaging into a contract for a good or services, like for say an app that you download to your iPhone or your Android device. So as a matter of constitutional right, people can freely retain and consent to the collection of their data and its use by others with minimal government interference. And as a result, the greatest driver of privacy protections thereby arises not from government enforcement, but rather through the established case precedent of lawsuit rulings, judicial decisions, administrative law, etc. And that brings us to the common law. Common law is that which is derived from judicial decision rather than by statute. It's otherwise known as case precedent. So under the common law, a tort is an act or an omission that gives rise to an injury or harm to another and amounts to a civil wrong for which courts can impose liability. So here are the most common types of privacy right violations. When seclusion has been intruded upon in an unreasonable and highly offensive manner, that can be thought of as the invasion of privacy. When information concerning private life is disclosed to the public in a highly objectionable fashion, you can sort of view that as unlawful disclosure. And also when business competitors engage in unfair competition through the theft of trade secrets. Now that's viewed as a sort of infringement on intellectual property rights. Now of these, the one that should have jumped out at you, again, was public disclosure of private information, which is pretty bad. So yeah, consent can definitely be a defense against a consumer or business-to-business claim alleging unlawful disclosure of private information, but we should always remember, consent is limited by scope, which means if your business is collecting data outside the scope of informed consent, and you suffer a breach, you're at extreme risk of incurring civil liability. Now, in addition to constitutional and common law privacy protections, regulations have also been codified by Congress. Federal administrators, state legislatures, state executive agencies, and they impose these regulations to shape business conduct. Now, these regulations establish the manner in which data must be collected, how it's processed, stored, disposed of, and disclosed in order to protect privacy rights. We see these statutory regulation frameworks in the form of GDPR, HIPAA, GLBA, CPRA, and much more. Now, here's a tip when dealing with competing statutory and administrative regulations. When state and federal laws conflict, always remember that federal law will displace or preempt the state law due to the supremacy clause of the U.S. Constitution. Now, preemption applies regardless of whether there's conflicting laws that come from a state legislature, judicial decision, state administrative agencies, or the state constitutions. Therefore, conflicting law between federal and state frameworks is never going to be a viable defense to noncompliance. You know the old saying, ignorance of the law is no excuse. So we should always be aware that state laws that are more stringent or restrictive than federal counterparts aren't necessarily assumed to be in conflict with one another. That means that state laws can go further than federal laws and be more restrictive, so long as they don't contradict. And they'll still remain enforceable, so they should be adhered to with a high level of diligence. Now let's ask ourselves, what exactly is privacy in a nutshell? Well, a couple definitions of privacy are as follows. The state or condition of being free from being observed or disturbed by other people, the right not to have one's personal matters disclosed or publicized, the right to be left alone, and the right against undue government intrusion into fundamental personal issues and decisions. So at its core, privacy calls for the protection of sensitive information. But how can the protection of that information be maintained? Well, by taking a principled approach, your organization can be regulatory agnostic. Common to all regulations are these privacy principles. So if you take a principled approach to your privacy program, you'll just naturally meet most of your regulatory requirements, and you'll protect the data that your organization is responsible for. This approach is simplified and it requires less expenditure of resources, which means it's easier to build and manage. It's better for your company and it's better for the personnel who work there. So here we've got the key components of a privacy program. We've got applicability, governance, use, notice and consent, access, security, and enforcement. So the business context of compliance. As discussed earlier, businesses are governed more so by the terms of private agreement than by actual laws. For instance, regulators can't go poking around your business without cause or your consent. They've got to have a reason to justify their presence, such as quality assurance or compliance monitoring. The opposite is true for private parties. Private entities can set whatever terms they want. Perhaps they won't do business with you unless you give them full visibility into the operations involving use of their data. Who knows what terms they're going to set? So to me, this means it's more accurate to think of contract parties as your oversight compliance officers rather than the government regulators, since private parties establish the granular rules that are going to govern your service agreements. And while it's true that government regulators have teeth, what type of action do you think is more likely to inflict harm on your business? An enforcement agency who's deliberating as to whether or not they're going to assess a civil monetary fine, or perhaps a party who will immediately terminate a service agreement upon breach of contract? So believe it or not, there's actually a limit to how much the government can fine you. I know that's shocking, but there's no limit to the amount of business that your organization might lose as a result of reputational harm and a degradation of customer trust. So the answer is pretty clear here. Enforcement by regulators could be quite a costly speed bump. However, enforcement action by a contracting party, that very well could mean termination of your agreement and potentially termination of your business if it's such a monetary hit. The practical approach here is to proactively concern yourself with the regulator that you're more likely to encounter, which are the organizations that you have business agreements with. Because more likely than not, the private organization you're under contract with is going to require you to comply with federal regulations as part of the MSA terms anyway. Now let's look at MSA compliance. What's the standard of care? So speaking of your compliance posture, under a master service agreement, parties typically have duties to comply with international, federal, and state regulatory schemes, as well as those duties which require heightened standards of care that are specified according to the contract terms. But what is a standard of care? So a standard of care is the degree of prudence and caution required of a person or an organization who has been charged with the duty of care. These duties can be imposed, again, by regulation or by terms of private agreement. The default standard that you should always focus on here is reasonableness. Reasonable care is the degree of caution and concern for the safety of the self and others an ordinarily prudent person would use in the same circumstances. This acts as a minimum baseline that must be satisfied, and failure to provide reasonable care in a situation can leave your business exposed to negligence claims. But what is negligence? So negligence is a failure to act reasonably and carefully, resulting in a harm or injury to another person. Negligence arises when the following four elements are met: duty, breach, causation, and damages. So if your organization enters into a business agreement, it may be agreeing to undertake certain duties and exercise certain standards of care. If these duties are breached, resulting in a harm, then a contract might be terminated on the basis of professional negligence alone. Now, that's a tricky one to look out for. Examples of this would be perhaps Facebook being fined over $800 million for a violation of a GDPR clause, HIPAA negligence enforcement actions. These are all common enforcement actions that are imposed by regulators for breaches of the standard of care or outright breaches according to a particular statute. So let's dive a little bit deeper into the alignment of compliance interests. We've got MSA compliance and we've got negligence per se. So if there is a law that prohibits the unauthorized disclosure of, let's say, health or financial information, and that law is violated by your organization via a negligent act, then it's assumed that a duty to exercise a certain care was breached. That's known as negligence per se. Well, Chris, why does this matter? Well, essentially, under the doctrine of negligence per se, if your business violates a state privacy law, then you can be sued and liability may be assumed. So if you break the law, not only could you be liable for criminal penalties, but you can expect that a civil action claim for damages is going to be an open and shut case based on the violation of that standard of care, the breach. Now I'm going to hand it off to Phil, who's going to identify some of the common problems and outline solutions for your organization.
Great, thanks, Chris. So we know what a business has to do. We know what the consequences can be. What are the challenges in actually implementing the solutions? So we have three common challenges. First, who owns privacy within the organization? The second, what are the regulations that you need to comply with? And third, how can you actually translate this into action? So we'll dive into each of these now. So the first component, the ownership problem. A lot of different parties within the organization have their hands in privacy. So if we think just about a simple solution, a SaaS-based platform, legal probably has the technical ownership of privacy. They're signing the MSAs and contracts. they're probably defining some general requirements. Product owner and engineering are going to be the primary parties that they'll actually need to work with to implement these requirements. So with the product owner, what's the data that you need to use this application? Um, how does that data affect privacy? So Jason Kronk's book, Strategic Privacy by Design, gives some interesting examples on just how early you should be getting involved in the design process to actually determine what's the data that needs to be captured in order to minimize the privacy impact. So this is a partnership that should begin very early on in the development process. It needs to translate into actual requirements for engineers. So how are they going to build the program to actually maintain the privacy principles? So commonly we see those three parties have at least a basic understanding and communication back and forth. Do you have a lot of other parties with just within the organization that are involved in maintaining privacy? So marketing is going to be interested in leveraging some of this user data to grow the company, create marketing campaigns. Um, Security is actually responsible for protecting the data. Security and privacy are going to be working very closely together because security is needed in order to maintain privacy. You also have a department in the organization that's dealing with vendor onboarding. Uh, Within the privacy universe, those are called sub-processors that have access to or store PII on your behalf. So they have the best inventory of those third parties. In working together, you identify what the privacy impact might be. Uh, what are you putting in the contracts with your vendors? HR is another party, not necessarily platform relevant, but they have a lot of sensitive data. They have several platforms that they're using. Um, Another important component of an enterprise-wide privacy program. That's really the answer, is creating a system of management for privacy. So the system of management is designed to get these parties together, get them talking. And then from there, you're able to generate information about how data is being used within the business, um, and take a systematic approach to recognizing and addressing potential risks around privacy. So we see this very often. Once all these parties start to communicate, you see additional data uses. So you have, for example, data analytics isn't specifically on here, but we've seen cases where there's an analytics team that's collecting data on how the platform is being used. In a lot of cases, previously, not all parties were aware that this kind of activity was taking place. So the management system really allows you to get more visibility into uh, how data is being used, and you can use that information in a useful way to protect privacy. So the next problem, we call it compliance whack-a-mole. Chris alluded to this already. You have regulations across industries, you have international scope, which is just multiplying. Same with states. You're quickly headed toward 50 states with privacy regulations. In addition, you might be imposed duties such as ISO 27701 or maintaining SOC 2 privacy compliance. So the answer here is the principles-based approach that Chris alluded to. This allows you to focus on the principles. All these regulations are designed to protect privacy. They're looking at certain facts and circumstances where privacy may be at risk, but at the end, they're primarily pointing back to this set of principles in how you build your program. The other big thing we're seeing around regulatory applicability is that more and more, as Chris alluded to with MSA compliance, it's becoming a question of what industries are your customers in. Arguably, you have a duty to know what data might be being handled within your platform. Is it still enough to put the responsibility on your clients to not upload PHI, for example? As we've seen clients, HIPAA in particular is the biggest area where we're seeing it so far, but we're seeing customers want assurance that if they're going to process PHI on the platform or just potentially thinking about doing it, they want to know that you have a HIPAA environment and you're HIPAA compliant. So that is a big area where we're beginning to see that MSAs are driving the regulations that you're subject to. So now we'll look at a few live examples that we see in contracts and the challenges you might face in implementing those. So the first one, uh, you can see the full text on the left side, but it pertains to confidentiality and privacy around health data. So at the very top, we see this relates to enrollee record accuracy requirements. So in this case was referring specifically to health enrollees. So the first component, abiding by all applicable laws. Well, clearly you have to know what the laws are there and develop a plan. And again, you see it's discussing medical records. The second component, ensuring that it's only released in accordance with those laws or pursuant to a legally binding order. We see this implemented on a few levels. So one, how you've actually architected the application with access controls to determine that only those who are authorized to access can see it and potentially disclose it. And two, anytime it's leaving the company, are you aware of that? Are you managing it properly and ensuring that it's going to only those authorized parties? And third, maintaining your records and keeping them accurately. So a process to keep data accurate, one just includes understanding the scope of what data you have, so data inventory, and then ensuring you understand how to maintain data quality. So is it through user participation? Are you going to be taking in updates from customers? Just an additional piece to make sure that's addressed. So already we see just one clause that has quite a few requirements for compliance. The next area is data retention. So again, the text is on the left side. We see there's a basic requirement that the vendor, think of that as your company, is required to either return or destroy all customer data at the end of the agreement. There are a few components to this. Again, understanding what that data is, where it is. Two, do you have a policy and procedures around data destruction? And three, it's not on here, but I'd say how, when a customer leaves, how is it communicated throughout the organization? Um, do you do you have a method to make sure that the parties who need to know are notified and you're tracking to make sure that the destruction or return of data is being done timely? Um, Now, what's interesting in this requirement, in the second clause, you see that there is an exception if you have a retention requirement based on a different legal reason. Uh, so here, it's an important exercise to go through retention. What applies to you based on different regulations? Potentially, it could involve all 50 states, which have varying record retention requirements and varying applicability there. Um, and then in the process to actually tag that data, um, make sure that you're retaining it in accordance with those laws if you're not going to comply with the first clause for various reasons. And finally, the last component is around backup data. We can jump back. Um, so for this, it's really just a process to understand your backup requirements and where those are stored. And in this case, so we see it's a area where legal, if it's owning the privacy program, would need to work with various different teams through that privacy management system to ensure they have that understanding and everyone's working together to understand and apply these requirements. So the last clause we'll look at is around data location. So we have we had a customer there, US based, all the infrastructure is located in the US. Uh, Middle of last year, they had one of their biggest customers come to them and say, we'd like to begin transferring some EU data to you, but we're going to need you to be GDPR compliant for that. So in that case, the customer actually had to go out, establish an EU presence, actually store that data in the EU in order to satisfy their partner requirements. So it's very much a real and growing issue. So this clause, in order to maintain the equivalent protections that Chris mentioned, requires that you not transfer the data outside of the EEA unless either of these requirements below apply. So the first is that a country has equivalent protections. It's actually under GDPR is decided by the EU if the European Commission decides that the country meets those adequacy requirements. The US does not currently, so that sends you to clause 3, requiring that you execute standard contractual clauses. This is an approved set of clauses, again, approved by the European Commission, basically requiring you as the vendor to implement those adequate protections. It also will address some of the concerns that stop the European Commission from approving the US as having adequate protection. So um, in those cases, you'll be asked to enter into these clauses. It's going to be a full suite of privacy requirements, but it allows you to transfer that data into the US. It can be a significant burden, and again, requires the principles-based approach and privacy management system to best ensure that you're actually able to comply with all of those. So you'll see quite a few other common terms in MSAs or potentially data protection agreements. So I'll run through these. Breach notification. GDPR says that a data processor needs to notify of any breach. They say without undue delay, which is commonly taken as up to 72 hours after becoming aware. Right to audit clauses are very common. Um, as we mentioned earlier, you might see requirements for a certification like ISO 27701. Um, Liability is going to be a significant area, depending on the size of the customer, what they'll want you to agree to around liability for breach of contract. Chris touched on that very well. Um, yes, several other key requirements here. There will be a significant security component. You might actually have to agree to comply with your client's security policy. You'll see data localization requirements, data retention, which we covered, as well as risk ownership. So this is most commonly seen in like a responsibilities matrix around privacy. This is a great area where you can proactively work on understanding what your requirements are um, in a typical contract and be able to communicate with your customers what you take responsibility for around privacy, what their what their responsibility is, because ideally both parties are working in concert to protect those rights of the individual throughout the data transfer and processing. So now I'll hand it over to Christian to talk through our approach and our playbook.
Thanks, Phil. Thanks, Chris. Awesome. So this is about the point in the presentation where I think a lot of folks are feeling pretty overwhelmed. There's a lot of regulatory considerations. There's various compliance and contractual considerations, and it can be overwhelming because how to handle all of them just seems impossible. So what do you do? So let's talk about trends and then the solution. So if you're wondering if this is here to stay, I think the answer is absolutely. What we've seen, especially over the last decade, and more especially over the last 5 years or so, is just more regulation and more contractual requirements. Virtually all of our clients come to us with questions about clauses in contracts, how to comply with them, or issues in the due diligence cycle where their sales are getting held up because companies don't know how to comply with them. So this is real, it's here to stay. So that means there needs to be a strategy. But you can't try to comply with everything. It's not feasible handling everything and interpreting everything, and there's conflicting requirements. Isn't feasible for most companies, especially most of our clients. They're kind of high growth tech companies. So what we propose is a right-sized solution to privacy that's principles-based. So it's not based on any specific regulation, but instead is based on adhering to those privacy principles and doing best practices to protect data, which naturally will flow into the regulatory requirements. So what does that mean you actually have to do? So common considerations, and I won't read all of these to you. You guys can take a screenshot of this. I think it's helpful, but there's a litany of things and policies and procedures and processes that you need to implement and embed into the business that will poise you to comply with those contractual requirements, to help you avoid negligence claims, to inspire confidence in your customers and your client base that you guys are taking privacy seriously, and ultimately say yes to contractual requests and due diligence claims. So that's where we get to our privacy program playbook. So this is where we try to put that playbook in human readable format and add some actionable steps that you guys can take to start building out your privacy program, specific deliverables, how to respond to different questions. So it can really operate as a guidebook for you guys. If you don't have resources on staff to execute against this, you don't have the bandwidth or you need expertise, Risk 360 can definitely help. But I think this privacy program playbook is a great place to start. If you want access to that, you can scan this QR code here on our screen. It'll prompt you to send an email to me, already pre-populated, just requesting that white paper. I'll get the email and then we'll send it over to you. You won't be put on an email list or anything like that. It's just email straight to me and I'll fire it back over to you. And that's a great place to get started. I know we have a few minutes left here, so I want to open it up to questions. We've already been submitted a couple, so I'll start asking those. So Phil and Chris, I'll ask questions as we go. And if you guys want to ask questions, thanks, Joseph. I see that you threw one in here. Please throw them in the chat, and I'll try to curate these and then get them answered by myself, Phil, or Chris. So here we go. Let me start off with a couple that I received question-wise. All right. One of the questions I got, Joseph, thanks, I see yours in there, I'll get to that one, is what's the difference between a risk assessment and a privacy impact assessment? So maybe Phil, you want to take that one?
Yeah, I'm happy to. So I think the best way to think of a risk assessment versus privacy impact assessment is risk assessment typically focuses on a risk to the business. A privacy impact assessment is very focused on the risks to the individual data subjects. So the term which comes up in GDPR is the rights and freedoms of data subjects. Chris alluded to this very eloquently because privacy is about rights and freedoms. A privacy violation can have significant impact on the individual. So in a privacy impact assessment, you're going to be focused on what are potential risks arising from the processing. So one that we always come back to is anytime you have automated decisions, those can have a binding effect on the individual. And for example, being improperly denied for a loan has a tremendous impact on the rights of an individual. Um, so in the privacy impact assessment, you will look at look at that and consider what are protections you can put in place to try to minimize that risk. The risk assessment will look a bit more globally at uh, how the business might be affected by just overall the kinds of data that are being collected, for example, and still risks around like a potential privacy breach, but uh, really what the bottom line impact to the business might be.
Yeah, expanding on that just a bit. So Chris talked about upfront, which was a very extreme example of how one of IBM's technologies were ultimately used, by the Nazi Party in Germany to identify people. And I think it's no surprise that GDPR was where it was in the EU and is where the idea of a privacy impact assessment was born, because really is asking companies to consider, I think the words that they use is the potential impact to rights and freedoms of the individuals by a given technology. So if you're developing a piece of technology, you're going to be gathering different types of data. What could be the potential impact of that technology, and asking companies to take some ownership and thinking through that is an exercise of a privacy impact assessment, which is I think an interesting and neat concept specific to privacy. Next question. So Joseph threw us a political landmine out, but I think it's a really good question. And he addressed this to you, Chris. In short, he says, hey, we have you spoke to the constitutional and sources of privacy rights, but we've seen, here recently with COVID or in the event of a disaster where various governments will suspend some of those rights in order for the sake of privacy. And he cites specifically, I'm guessing, like, for example, COVID passports, or we saw under the National Defense Authorization Act where, there was enhanced screening to go through airports. So what's the balance of, constitutional, traditional ways that we think about privacy and maybe government's ability to intervene?
Yeah, that's a great question. I think in the era of COVID, a lot of organizations are trying to respect their personnel's privacy rights as well as comply with federal mandates. So, Joseph, to that, I would answer your question by, hearkening back to, years ago, I had a constitutional law professor who was extremely bright. We learned a lot of things, but what stuck with me the most was this sort of key theme that he would always be a proponent of, and that is the notion that the executive branch has all the guns. And now I don't mean that literally in the sense that they have, firearms that they'll be using against you, but rather they have enforcement power that can guide and conform private conduct by enforcing penalties, et cetera. Now we sort of see that with like OSHA interpretations of known risks, right? They've essentially classified COVID-19 as a known risk, and therefore have imposed a standard of care and a duty on private organizations. Now, the issue is essentially In order to comply, it may require the disclosure of personal information, personal health information, which could potentially be a breach of HIPAA. So what do you do? Well, my recommendation is if you're going to worry about privacy compliance, you should follow the guidance of the executive branch. And that might be playing it safe, but it's important because the executive branch are the ones who can impose a fine or shut you down for the violations. So in times of emergency, we tend to see that courts give great deference to the executive branch, right? Like they're in the driver's seat for the country. We respond to acts of war by looking to the executive branch to sort of deal with that situation. And furthermore, Congress tends to be slower to react given their Republican nature, small r. And I would say that the separation of powers is theory, yes, but in a real world practical scenario, your best bet as an organization is to follow the advice of the regulators in the executive branch. So you're likely safe if you're complying with the executive branch, despite the fact you might have considerations about HIPAA compliance. But remember, everyone's going to have those issues of whether or not they are potentially breaching those privacy rules.
Thanks, Chris. I'll do a couple more and then we'll close out here. Phil, maybe this is a good one for you. We have some questions around, do you see any trends in terms of different privacy certifications or ways to evidence to, customers and clients that want to know that you're doing the right thing when it comes to privacy? So we see any trends when it comes to certifications?
Yeah, we're seeing ISO 27701 is the biggest trend we're seeing right now. So the standard, I think, just had its second birthday. Um, at first it was very early adopters. I think we're probably still in the early adopter stage. We're seeing growing demand there. That's probably the biggest one. The other thing I would say, I might die on this hill, but I would say that completing the privacy impact assessment to me is just a critical component, particularly when you're acting as a data processor. Um, I think having that in your arsenal is a great way to show that it's more than just implementing a few additional privacy controls. It's truly a way of thinking, often in conjunction with your management system, to show that you're serious about the privacy of the data that you're collecting within your systems. So I think proactively doing that, taking the exercise seriously as a processor is a great way to really make an impact in the minds of your stakeholders.
Yeah. One other thing I'll throw out there is probably everyone on this webinar is familiar with the SOC 2 report. So SOC 2 does have a privacy criteria that you can add on to your SOC 2 report. And then in the back of your SOC 2 report, it's called Section 5 generally. It's an area where you can provide any additional information that you would like to people reading your SOC 2 report. And one of the best uses of that that I've seen is mapping what you're doing in SOC 2 and how it helps you meet, let's say, GDPR compliance or HIPAA compliance or others, so that as you're handing your SOC 2 report to your various stakeholders, they can go to that section and see how your audited controls are mapping back to these privacy regulations. And while it's not an official certification, it's at least demonstrating, helping you tell your story when it comes to privacy and mapping those processes back. So if you're not doing that, mapping, say, HIPAA, GDPR, or whatever in Section 5 is a really good way to do that. Okay. All right, guys. I don't see any other questions. So last bit of admin, if you would like a copy of this webinar to share, we will be redistributing this on the back end of this. If you register for the webinar, we'll probably share it on YouTube as well. So thank you everybody very much for participating and joining us. Thank you, Chris and Phil. We appreciate it.